Article 45.046 of the Texas Code of Criminal Procedure, titled Commitment, provides that when a judgment and sentence have been entered against a defendant, and the defendant defaults in the discharge of the judgment, the judge may order the defendant confined in jail until discharged by law if the judge at a hearing makes a written determination that the defendant is not indigent and has failed to make a good faith effort to discharge the fine and cost, or the defendant is indigent and has failed to make a good faith effort to discharge the fines and cost by performing community service per Article 45.049 and could have discharged the fines and cost under Article 45.049 without experiencing any undue hardship.
In the context of fine-only misdemeanors that are handled in municipal and justice courts, commitment refers to committing someone to jail in order to discharge their fines and costs after they have defaulted on judgment. It is certainly a last resort, but at times a necessary method of enforcing a court's judgment and sentence. When we speak of commitment and commitment orders, in the case of fine-only misdemeanors, we're dealing with cases where a defendant has defaulted in discharging that judgment. Article 4505 states that if a defendant is not in custody when the judgment is rendered, or if the defendant fails to satisfy the judgment according to its terms, the court may order a Capias pro fine issued for the defendant's arrest. The Capias pro fine states the amount of the judgment and the sentence and commands a peace officer to bring the defendant before the court immediately or place the defendant in jail until he can appear before the court. After this arrest happens, the judge sees the defendant to have a commitment hearing.
While the Capias pro fine results in a defendant being arrested, a Capias pro fine is not a commitment order.
Commitment hearings are required prior to someone ever being committed to the jail in order to satisfy a fine or costs that are due to the court. Commitment hearings are required prior to someone ever being committed to jail after failing to pay or discharge the judgment in a fine-only misdemeanor case. Article 45046 of the Texas Code of Criminal Procedure outlines the requirements for a judge committing a defendant to jail. When we talk about the commitment process, we're really talking about Capias pro fines. We're not talking about any other process prior to that. What we're trying to do is determine whether or not the defendant has failed to, willfully or otherwise, chosen not to pay a fine when they could have paid the fine. Where it's never appropriate to put someone in jail immediately after pronouncing sentence, even if they entered a plea or intended to, sometimes even if they profess that that's what they want to do. Our goal is to determine whether or not they can pay the fine, where it's appropriate, and whether or not they're willful in not paying the fine, and then to offer them other alternatives such as time to pay or some other form of satisfying the fine other than putting them in jail. A commitment hearing is required by law prior to ever placing that defendant in jail. That's the crux. That's the whole point of what we're talking about, is that they shouldn't be placed directly from jail. They should be brought before the court, before the judge, and that judge, in their capacity as judge, makes a determination prior to placing them in jail. Now, I know that people have been arrested on the Capias pro fine very often, and maybe they're in jail. So we need to perform that function before they continue to stay in jail. And the issue is whether or not that is a form that we feel is appropriate for them to satisfy their fine and cost. We know from a practical standpoint that most commitment hearings, most processes, most magistrations all take place in the context of a jail. And so if we are to perform them there, and most of us are somewhat forced to by the process that's given to us, then it needs to be done where the defendant clearly understands that they are before the judge of the court and that they have some choices and options. So it's not a slam dunk. It's nothing that we simply fill out a form and commit them to jail. It has to be a courtroom proceeding. So to that extent, it needs to have all the trappings and formalities of someone who would appear before the court, and the court actually hear their case, consider what they have to say, and apply what they've learned through their conversation. as a matter of fact, really in my court, now everybody who is there is going to be released on a promise to come back into the court where we can assess their ability to pay. I really don't believe that most people who have been arrested on a Capias Pro fine have access to the information that they would need to develop their fact that they are not as poor as they are, or that they can or cannot pay. So to that effect, I use the Capias Pro fine to bring the person before the court. But once they're before the court, then I will release them to a court date where they can appear. So I've kind of bifurcated the process, but I do understand that most Capias Pro fine commitment hearings are done in a jail, but the defendant needs to feel as if they have the ability to affect the outcome. I think probably the biggest thing that sticks out of my mind is just because someone had a due date for a fine and cost and they didn't pay it, maybe at the time that judgment was entered and at the time they had asked for additional time, they could have or thought they could have paid it, but things have changed since that time. And so now when they're in jail, they can't pay it. The issue is indigency. Before a judge commits someone, the judge must make a written determination after the hearing, finding one of the two following options. Either one, the person is not indigent and failed to make a good faith effort to discharge the judgment, or two, that a person is indigent and failed to make a good faith effort to discharge the judgment and could have discharged the judgment through community service without experiencing an undue hardship. Now, if the judge makes either of those two determinations, then the judge may commit the person to jail to discharge the balance of the judgment. But if a judge does not make one of those two determinations, then the defendant must be released. This could be because the defendant has satisfied the judgment through jail credit or payment, or the defendant could be released with an order of community service or a continued payment plan. And if the judge finds that the defendant is indigent and that community service would be an undue hardship, then the judge may consider waiving the fine and cost under Article 450491, and the defendant would owe nothing. Well, many argue that it is the defendant's obligation to raise the issue of indigency or their inability to pay, but that's not true, not as a part of the commitment process. As we discussed, the judge must, in writing, determine whether a person is indigent or not during the commitment hearing. It is the judge's finding, and central to the commitment process is why the defendant failed to pay. To leave it solely to the defendant to allege indigence or a failure to pay would surely result in the illegal jailing of indigent defendants. Many defendants simply don't know to raise the issue, or they may not know how to raise the issue. Some are intimidated by where they are. But the short and long of it is a court's obligation and duty to inquire and to listen to the information that's given to them in return. I think the decision for the judge should be at that moment, when that person is standing before you on that Class C Capias Pro fine, do they have the ability to pay you then? Or do they even have the ability to answer the question with enough specificity that you can determine whether or not they're indigent? And if you can't, then I think you err on the side of release and maybe reassignment for a date for them to come back where they can show you that they are truly indigent or not indigent. Well, it could be a lot of things, but I think here are some of the things that you certainly should ask, that you should maybe have written record of their answers so that you can preserve that as part of your record, even in courts of non-record. I'm going to urge you to take careful steps to make sure that you retain some of this information so you can support your position at a later time. But I think you should certainly ask questions and consider information about the amount of income that they currently make, the source of their income, including their wages, offsets to that, including loans and costs that they may have, and whether the defendant has the ability to post bail or cash bond. You need to also consider the defendant's expenses, because that's certainly part of what they have to live with in day-to-day life. the number and ages of dependents, their rent and mortgage payments that they have due, debts and obligations, personal expenses, at least give them an opportunity to kind of outline what they may be, and illness and incapacity of the defendant, particularly if you're talking about the inability to perform community service. Because if you're going to find that they're indigent, and also look at that issue of whether or not they're able to satisfy the fine by way of some kind of community service, physical disabilities might be a consideration as well. And to considering other evidence, including their ability to work, spouse's condition. I wouldn't go so far as to broaden it out to family and friends, but I think spouse's income can certainly be considered. And factors that you shouldn't consider, maybe just as important, you shouldn't consider their financial resources of parents or exempt property from homestead by law that's protected. And I'm particularly going to caution judges to avoid the last one, do not consider the defendant's attitude. Attitudes in jails can be a completely infectious matter, and they'll slew your opinion from one side to the other pretty quickly if you're not careful. So look at the information they give you. Their attitude, while it may be an indication of their ability to come back and take care of business later on, whether or not they're indigent should never depend upon the attitude that they display at the time of their arrest.